Section 2, subsection 60. Officers who is in default. For the purpose of any provision in this Act which enacts that an officer of the company who is in default shall be liable to any penalty or punishment by way of imprisonment, fine or otherwise, means any of the following officers of a company, namely whole-time director, key managerial personnel. Where there is no key managerial person, such director or directors as specified by the board in this behalf, and who has or have given his or their consent in writing to the board to such specification, or all the directors if no directors is so specified. If any person who under the immediate authority of the board or any key managerial personnel is charged with any responsibility including maintenance, filing or distribution of accounts or records, authorizes, actively participates in, knowingly permits or knowingly fails to take active steps to prevent any default, any person in accordance with whose advice, directions or instructions the board of directors of the company is accustomed to act, other than a person who gives advice to the board in a professional capacity. Every director, in respect of a contravention of any of the provisions of this Act, who is aware of such contravention by virtue of the receipt by him any proceedings of the board or participation in such proceedings without objecting to the same, or where such contravention had taken place with his consent or connivance. In respect of the issue or transfer of any shares of company, the share transfer agents, registrars and merchant bankers to the issue or transfer. The meaning of officers in default. The officer in default is the person or group of people held legally responsible when the company commits a violation of the Companies Act. Who can be in officers in default? Whole-time director, full-time director actively managing affairs, key managerial personnel, KMP like CEO, CFO, company secretary, etc. Specific directors. If no KMP exists, the board can designate one or more directors in writing. If no one is designated, then all directors are responsible. Responsible employees. Any person under authority of board or KMP who handles accounts, records, filing, etc., actively participates, authorizes or knowingly ignored defaults. Shadow directors. Anyone not just officially on record whose advice or directions the board usually follows, except professionals, that is lawyers, CS, etc., giving advice in their job capacity. Complicit directors. Any director who knew about the violation through meetings, minutes, etc., and didn't object, consented or connived in the violation. External agencies. In case of issue or transfer of shares, share transfer agents, registrars, merchant bankers. For example, XYZ Limited fails to file its annual returns. If there is a company secretary, KMP, he is the officer in default. If no KMP, the directors designated by the board. If nobody is designated, all the directors are liable. If a director knew but kept quiet, he is also liable. So, liability spreads like a safety net. Someone will always be caught. In short, officers in default who gets the blame when the company breaks the law. If you had power, knowledge or duty and you didn't prevent the wrong, you are in the one in trouble.